There's a specific afternoon most of us remember. You've been renting for years, maybe most of your 30s, moving when the lease ended, keeping one eye on the calendar, never quite settling. And then one day you're sitting across a folding table from a title agent in a room that smells like carpet cleaner and old paper, and there are documents in front of you. 37 pages, give or take. You sign your name so many times your signature starts to look like a stranger's. And then someone slides a key across the table. You drive home, not to an apartment, not to a place you're borrowing, to a house that is, for the first time in your life, yours. If you bought in the late 90s, maybe you got lucky on rates. If you bought in the mid-2000s, maybe you watched the value crater and held on anyway. Either way, you held on. You made the payments. For a lot of us, paying off that house felt like finishing something, like evidence that the plan worked. Nobody at that closing table said anything about what happens to that house 30 years from now. Not the agent, not the attorney, not the loan officer who called you twice to confirm your income. The entire conversation that day was about getting in, how to qualify, how to close, what you owed, and when. There's a federal program, one that's been active since 1993, that most homeowners in their 50s and 60s have never heard of. And the reason they haven't heard of it isn't that it's rare or complicated or only applies to other people. It's that there's no moment in the home buying process where anyone has any reason to bring it up. Closing attorneys aren't long-term care planners. Nobody's thinking about Medicaid when you're 38 and signing your name. We're going to talk about it now. One honest note first. I'm not a lawyer or your financial advisor, and nothing here is personal legal advice. It's just the information our generation was never handed at the table where it would have mattered most. So you can ask the right questions while there's still time to act on them. If this is useful, share it with someone in your circle who owns a home and is getting close to that conversation. The program is called the Medicaid Estate Recovery Program, MERP for short. And before you tune out because you don't think of yourself as a Medicaid person, stay with me for just a minute because that's exactly the assumption this program depends on. Here's how it works. Medicaid long-term care, the kind that pays for a nursing home or in-home care when someone can no longer manage on their own, is means tested. That means you have to be nearly broke to qualify. Most states set the individual asset limit at around $2,000 in countable assets. That's not a typo. $2,000. But here's the part that surprises people. Your home doesn't count against you for eligibility purposes. The house you paid off, the house that represents 30 years of payments and every financial decision you made, Medicaid looks at it and says, that doesn't count. You still qualify. Federal rules protect home equity up to somewhere between $752,000 and $1.13 million depending on the state. For most of us, the house is well under that ceiling. So Medicaid says yes, you get the care, the state pays the bills, and then you die. Now the rules change. Because once you're gone, that house is no longer an exempt asset for eligibility purposes. It becomes part of your probate estate. And the state, which has been keeping a running tab on everything it spent on your care, files a claim against it. That's the mechanism. That's what nobody mentions at the closing table. Federal law has required every state to run this program since the Omnibus Budget Reconciliation Act of 1993. For anyone who receives Medicaid long-term care services at age 55 or older, states are mandated to seek recovery, nursing facility costs, home, and community-based services, related hospital and prescription drug costs. It's not optional. It's not a policy some states chose. It's federal law, operating in all 50 states for over 30 years. Here's the thing I want to be precise about, because this part gets misunderstood. It's not the paid-off home that triggers estate recovery. A mortgaged home in a qualifying estate faces exactly the same risk. What triggers MERP is the care you received. Medicaid long-term care services after age 55. The home just happens to be, for most people in this situation, the only asset of significant value left in the estate. Think about it. To qualify for Medicaid, you've spent down nearly everything else. the savings, the secondary accounts, the non-exempt assets, gone or spent on care before Medicaid kicks in. What remains is the house, and the house is what the state comes for. Here's what makes this especially hard to see coming. The home passes every Medicaid test. It gets you through the door. It's only after you're gone that the rules flip. You didn't do anything wrong. The house did exactly what it was supposed to do at every stage. The problem is that the test was designed to measure eligibility, not to protect what you leave behind. That distinction matters, and it's the one that never comes up at the closing table. Let's put some numbers around this, because abstract risk is easy to dismiss, and these numbers are not abstract. A private room in a nursing home costs nearly $130,000 a year right now. That's the national average, roughly $10,978 a month according to the most recent CareScout data. And that's not the high end. That's the middle of the country, average facility, average care level. The average nursing home stay in the United States runs somewhere between 2 and 3 years. Do that math. 2 years at $130,000 is $260,000. That's a claim. A real one filed against a real estate by a state that has been tracking every dollar it spent on your behalf. And for most people who end up in that situation, the estate they leave behind consists almost entirely of one thing: the house. This isn't a theoretical edge case. In fiscal year 2019, the last year with comprehensive federal data, states recovered approximately $733 million through Medicaid estate recovery programs nationwide. That's $733 million pulled from the estates of families who, in most cases, had no idea this was coming. Real houses. Real heirs who showed up expecting to inherit something and found a lien waiting for them instead. Now, in some, and this is important, not every state pursues recovery the same way. The federal law sets a floor, and roughly 2/3 of states expand beyond it. About 37 states go further than what federal law requires, covering additional services, broader age ranges, or a wider definition of what counts as the estate. The remaining states stick closer to the federal minimum. That variation matters for you personally. This video explains the federal structure, the rules that apply everywhere. Your state's specific rules are the ones that govern your situation, and they may be more aggressive or more limited than what we cover here. Checking your state's Medicaid estate recovery policy is one of the concrete steps worth taking after this. There's one more layer to this that catches people off guard, and I want to flag it carefully. About half the states, roughly 27 of them, use what's called an expanded definition of estate recovery. That means they don't just pursue assets that go through probate. They go after property that would otherwise pass directly to heirs outside the probate process entirely. Jointly owned property with right of survivorship. Assets held in a basic living trust. Certain annuity payments. Certain life insurance payouts. The reason that matters is that a lot of the common advice people get, put the house in joint tenancy, set up a living trust, may not be sufficient protection depending on where you live. In an expanded estate recovery state, those tools can still be reached. Joint titling is not a guaranteed shield. A basic living trust is not a guaranteed shield. The solution depends on your state and the specific structure of your plan. Before we get into what actually works, the exemptions, the strategies, the 5-year window, there's one more piece of this I want to sit with for a moment, because understanding the mechanism and the numbers still leaves a question open. How did an entire generation of homeowners get this far without anyone ever mentioning it? There's no villain in this story. That's what makes it harder to be angry about. The closing attorney who handed you that stack of documents wasn't hiding anything. Their job ended the moment the deed transferred. Long-term care planning wasn't in their scope, wasn't in their training, and wasn't something you were paying them to think about. They did exactly what you hired them to do. The loan officer wasn't hiding anything either. Neither was the real estate agent or the title company or the bank. Every person at that table was focused on one transaction: getting you into the house. What happens to the house 40 years later when you're 82 and the state has been paying your nursing home bills for 2 years? That's somebody else's department. except nobody ever figured out whose department it was. And then there's the assumption most of us carried out of that room without even knowing it. The quiet belief that Medicaid was for other people, for people who never had much, not for someone who owned a home, had a retirement account, made the payments. We didn't think of ourselves as people who would ever need to navigate Medicaid, so we never looked at the rules that govern what Medicaid can do. The lag is the third piece. MERP was written into federal law in 1993. The people it will affect most are the ones who were buying their first homes right around that time, in their late 20s and early 30s, thinking about mortgage rates and school districts, not about a federal reimbursement program that would only matter if they needed long-term care 3 or 4 decades later. 30 years is too long a gap for a warning to travel through. By the time it's relevant, the moment to act may already be narrowing. Here's the thing I keep noticing about how our generation processes financial risk. We were trained to protect against what we could see. The monthly payment, the adjustable rate, the job that might not be there next year. We watched our parents' generation lose pensions they were promised and never questioned, and we swore we'd read the fine print. We opened the IRAs ourselves. We rolled over the 401ks ourselves. We figured out the Roth conversion rules and the backdoor contributions and the sequence of returns math, mostly on our own because no one handed us a guide. What nobody built a system to protect against was the invisible rule. The one written quietly into a budget reconciliation bill the year after the first Clinton inauguration, that doesn't touch your family until you're in your 80s, and the people who might have warned you are long gone. We were never handed this page. That's not an excuse, and it's just true. And the generation that taught itself to read the fine print deserves to actually have the fine print. The home passed the test. Every time. That's not the problem. The problem is that the test was measuring something different than what we thought it was measuring, and nobody in the room was responsible for explaining the difference. That's where we are. And now that you have the map, let's talk about what you can actually do with it. The good news is real, and I want to lead with that because everything we've covered so far can start to feel like a closed door, and it isn't. There are exemptions built into federal law that block estate recovery entirely in certain situations. There are planning strategies that work, and there is a window of time, a specific, measurable window, where the people who act come out on the other side of this in a fundamentally different position than the people who don't. So let's walk through all of it. The federal exemptions first. If you are survived by a spouse, the state cannot touch the estate while your spouse is alive. Full stop. That protection is written directly into federal law and applies in every state. No claim is filed, no lien attaches, no recovery proceeds, as long as your surviving spouse is living. Now, that doesn't mean the issue disappears permanently. It means recovery is deferred. When the surviving spouse eventually passes, the estate may still be subject to a claim for both spouses' combined Medicaid costs. But the immediate protection is real, and it is significant. For married couples, the spousal protection is the first line of defense, and the Community Spouse Resource Allowance, which sits at $162,660 in most states in 2026, provides additional protection for the spouse who remains at home while the other receives care. Recovery is also blocked if you are survived by a child under the age of 21 or a child of any age who is blind or disabled. Those protections exist at the federal floor and apply in all states. Then there's one that genuinely surprises people when they hear it. The caregiver child exemption, federal law, specifically 42 U.S.C. Section 1396P, contains a provision that allows a full transfer of the home to an adult child who lived in that home for at least 2 years immediately before the parent entered a nursing facility, and who provided care during that time that demonstrably delayed the need for institutionalization. If that describes a child in your family, a son or daughter who moved back in, or who was always there, and who helped you stay home longer than you would have otherwise, that child may qualify to receive the home free of any Medicaid estate recovery claim. This is one of those rules that exists quietly in federal law, almost never mentioned at the planning table, and it protects a family dynamic that actually describes a lot of households in our generation, adult children who stepped in, who reorganized their lives around a parent's care, who kept the parent at home when the alternative was a facility. The exemption was designed for exactly that situation. Most families who qualify for it have no idea it exists until it's too late to document properly. Documentation is the key word there. The care has to be real and it has to be traceable. An elder law attorney can help structure that correctly if the situation applies to your family. There's also a sibling exemption for a sibling who held an equity interest in the home and lived there for at least 1 year before the Medicaid recipient was institutionalized. Less common, but it exists and it matters in the families where it applies. And every state is required by federal law to offer an undue hardship waiver, a process where an heir can petition the state to waive recovery on the grounds that enforcing the claim would cause genuine financial hardship. It's not guaranteed. The bar varies by state, but the door is open, and in the right circumstances, it can be walked through. Those are the exemptions, the situations where recovery is blocked by law. Now let's talk about the planning strategies. Because for most people, the exemptions aren't the answer. The answer is acting before you ever need Medicaid at all. This is where the 5-year look-back period becomes the central fact of the conversation. Medicaid has a 60-month look-back window, 5 full years, during which any asset transfers you made are scrutinized. If you gave away your house, put it in a trust, transferred it to a child, or restructured your assets in any way to reduce your Medicaid countable estate, and you did that within 5 years of applying for Medicaid long-term care, the state can impose a penalty. That penalty takes the form of a period of Medicaid ineligibility, calculated based on the value of what was transferred. You could end up in a facility that Medicaid would otherwise cover, ineligible for coverage because you moved assets inside that 5-year window. California is the notable exception here. The state is phasing in its own look-back period, starting at 0 months as of January 2026 and gradually reaching 30 months by July 2028. If you're in California, the rules are different and actively changing. But for 48 other states and the District of Columbia, the 5-year window is the standard. What this means practically is that the strategies that actually work, the ones that protect the home from estate recovery, have to be put in place well before you apply for Medicaid. Not when the health crisis hits, not when you're already in a facility, 5 years before that, at minimum. The 3 most commonly used tools are Medicaid asset protection trusts, life estate deeds, and strategic titling, each with different trade-offs depending on your state, your family structure, and how much flexibility you want to retain over the property. A Medicaid Asset Protection Trust, a MAPT, is an irrevocable trust you transfer the home into. Once it's there, the home is no longer in your name, which means it's no longer part of your probate estate for recovery purposes. You can still live in the home. You give up the ability to sell it or take it back unilaterally. It's irrevocable. But the asset is protected if the 5-year clock runs before you apply for Medicaid. A life estate deed is a simpler structure. You retain the right to live in the home for the rest of your life. That's the life estate, while transferring ownership of the remainder interest to your heirs now. At your death, the home passes directly to them outside of probate and, in many states, outside the reach of estate recovery. The trade-off is that you've given up full control of the property, and in expanded estate recovery states, even life estates can sometimes be reached, which is why state-specific legal advice matters. There is also pending federal legislation worth knowing about. The Stop Unfair Medicaid Recoveries Act, introduced in January 2026, which would repeal the federal mandate for estate recovery in certain circumstances. It has not passed. As of mid-2026, no federal restriction has cleared Congress. Follow it, but do not plan around it. The strategies that protect your family are the ones that work under current law. Here's the honest framing on timing. If you're in your early to mid-50s, the 5-year window is open and comfortable. You have time to plan carefully, choose the right structure for your state, and get it done without pressure. If you're in your mid to late 60s, it's still workable. But the time to think about this is now, not during a health event, not when someone is already in a facility and the window is closed. The people who navigate this well are not the ones who moved fastest in a panic. They're the ones who found out early enough to have one conversation with an elder law attorney before it became a crisis. One more thing before we close. Because of the expanded estate recovery rules in roughly half of all states, some of the most common informal planning moves, putting the house in joint tenancy, setting up a basic revocable living trust, may not be sufficient on their own. In those states, those structures can still be reached. Getting state-specific advice from a Medicaid-credentialed elder law attorney isn't a formality. It's the difference between a plan that holds and one that doesn't. If any part of this applies to your situation, that conversation is the action item. Not a product, not a financial instrument. A conversation with someone who knows your state's rules, while the clock is still running in your favor. Let's go back to that afternoon. The folding table, the carpet cleaner smell, the 37 pages and the key sliding across the table toward you. The person sitting in that chair, the one signing their name over and over, thinking about paint colors and whether the water heater was going to hold another 5 years, that person wasn't thinking about long-term care. Why would they be? They were 38. They were thinking about getting in, about finally having something that was theirs. That person did everything right. Made the payments, held on through 2008 when the value dropped and the news said, walk away, and something in you said no. Paid it off. Felt the specific satisfaction of a mortgage statement that reads 0. They just didn't have this page. And here's what I keep coming back to. This generation, our generation, is not one that needs to be frightened into paying attention. We've been reading the fine print our whole lives. We had to. Nobody handed us the pension. Nobody guaranteed the outcome. We learned to roll over the 401k ourselves, to decode the COBRA paperwork ourselves, to figure out what our parents never had to figure out, because the institutions that were supposed to handle it stopped showing up somewhere around the time we were old enough to notice. We know how to act on information. What we needed was the information. The Medicaid Estate Recovery Program has been federal law for over 30 years. The 5-year look-back period is the clock that governs whether the strategies that protect your home have time to work. The exemptions are real. The spousal protection, the caregiver child provision, the undue hardship waiver. And most families who qualify for them never know to ask. The tools that work, the Medicaid Asset Protection Trust, the life estate deed, the right titling structure for your state, are not complicated once you're sitting across from someone who does this for a living. The gap isn't knowledge. It's just timing. The families who come through this well are the ones who had this conversation while the 5-year window was still open, wide, and unhurried. If that's you right now, if you're in your 50s or your early 60s and the house is paid off or close to it, the thing to do is not to panic. It's to make one phone call to an elder law attorney who knows your state's specific Medicaid estate recovery rules. Not because something is wrong, because something is workable, and the window is open, and that is exactly the moment to use it. One honest note on all of this. Nothing here is legal advice, and the right answer for your situation depends on your state, your family structure, and details that belong in a conversation with a qualified professional, not a video. What this is the information our generation was never handed at the table where it would have mattered. So you can walk into that conversation knowing what questions to ask. Did you know this existed before today? Genuinely. Drop it in the comments. I'm curious how many of us are hearing about MERP for the first time right now versus how many found out the hard way, watching it happen to someone else's family. Either way, that's the conversation worth having. And if someone in your life owns a home and is getting close to this window, this is the video to send them. That's what the closing table left out. Now, you have it.